on the call today. So we'll see. All right, so we are streaming live. Let's get started. Hello, everybody. Welcome to our Facebook Live and our ILA and KelpHR Connect. Madhura, you would want to take up?
Yes. Hi all, good evening. Welcome to the session on the case laws under the PoSH Act. The session is jointly hosted by ILA, Indian Lawyers Association, and KelpHR. I represent ILA, so here is a quick brief about what we do. We are the largest organization of Indian lawyers, and we have a presence in 75 plus cities all over the country. We do a couple of initiatives and activities which benefit the lawyers in some or the other way. Also, we have a very active legal clinic, and we have recently started doing activities for law students. Tomorrow, I'll be sharing more information about what all we do over email with all of you. I hand over the session to Smita, who is moderating the session today. Smita, over to you.
Thank you so much, Madhura. And we have been doing various sessions on prevention of sexual harassment law, a law which came to us in 2013. And there are a lot of questions that people come back and ask us. So we said, why not simplify this? One of the most important aspects of this law was understanding various case laws which came around it, before it, after it, and is continuously coming, right? So let me start by introducing myself. My name is Smita Shetty Kapoor. I am the co-founder and CEO of KelpHR. We started in 2013. We started to be something called as subject matter expert in this particular thing because I was part of a really large organization which used to work when Vishaka guidelines was also around, and I've been sitting in the internal committee. And when I thought of setting up a company, I realized that we didn't have a single organization at that point of time which did end-to-end work in the space. So that is how we started. Let me now take a quick opportunity to introduce this eminent speakers here. So I'm going to be sharing my screen. If you can see it, just give me 1 minute, it is coming up. And here we have with me Aline, Rajkumar, and Ashtawat. Sorry about not pronouncing your name correctly, Ashtawat. So she has an experience of 13 years at bar, and she's handled a plethora of cases before various courts, tribunals, statutory and regulatory authorities, commissions and forums, and has helped her develop a distinctive perspective of civil, criminal, and matrimonial litigation. So her specialized area is to practice in matrimonial and family dispute resolution. That's Aline Marcus for you. Rajkumar Srivastav is a partner with SK Vestigam LLP. He is been an advisor to Protivity Consulting Firm 2. He's been a former law enforcement officer, certified fraud examiner, science and law graduate. He has 31 years of experience investigating frauds. So we'll be able to pick his brains. He's been a recipient of 140 plus awards and notes and letter of appreciations from various forums. So he was decorated with the Director General of Police insignia for meritorious service also. Welcome, Rajkumar Srivastav. We also have Ashtawat Balan with us. He is a senior associate with IC Universal Legal. He has been a member of corporate and transactional team. He is a contribution on such transaction ranges from being involved in due diligence and providing full assistance until the closure of transactions and even thereafter. Prior taking his law degree, he worked as an associate analyst with Deloitte, so in Hyderabad. So that's our forum for all of you. So what is case law? Okay, if I have to ask anyone who comes from a fraternity who's not a lawyer, so I have tried to simplify it from a layman's language for each one of you. Then we'll pick all these speakers' brains about what do they understand about case law. So case law is based on decisions that judges have made in past. Okay, something which might have gaps in the written law and basis two parties who are conflicting at that point of time, they come up with these decisions to resolve those ambiguities which they would have come to. Okay, it is made by courts or by tribunals. So coming to you, Rajkumarji, what do you think about this? Is this definition or is this explanation about case law good enough?
Yeah, I think, Smita, what you told is right, because these are not the legislative laws. These are not the laws passed by the legislature. But as you rightly mentioned, that in the existing laws, when there are some gaps or few things are missed out while drafting a law by the legislatures, and when the practical things come out before the court, and when there are no answers, in such cases, the High Courts and the Supreme Court, they try to find out the way to decide that particular case. And we inherited this concept from the British Parliament, because we were ruled by the British in the past, and in fact since then this case law concept is very much prevalent in the Indian judicial system, and that is what we rely upon. And there are, for everything there are case laws, and we depend upon those. For example, if you see here in this particular law also, in 1997, the Vishaka guidelines came into the force. And in fact, the law judgments passed by the High Courts and the Supreme Courts itself is the law. And in that particular judgment in the Vishaka case, in fact, the Supreme Court clearly told that until the legislature formed the statutory law in this particular matter, this judgment will be treated as a law or the act by all the companies, whether it could be private or the government organizations, any institutions, or any establishment. That is how, I mean, this common law is very prevalent in the Indian judicial system.
Okay, awesome. Eileen, what do you think about it? Do you think we have given a comprehensive definition of what is case law all about?
In addition to that, what I have to say is, whenever there is no law and there are certain ambiguities, like you pointed out, in terms of ascertaining few aspects, that is when case laws are there. So one we have with regard to Vishaka. Then when we look at laws relating to women, it is very difficult to define every crime or every aspect of crime. So there you have case laws or precedents by the Honorable Supreme Court that lay the way on how do we move forward. So generally, we look at cases for procedures, we look at it for definitions, and we look at it for clarity in the law itself. This is just whatever you do.
Eileen, thank you so much. Ashtavat, anything from you, or we have covered everything?
I think the other two panelists have pretty much covered everything. Just to add on, like they said, that it's just the lacuna that may be present in a particular legislation is filled in by these case laws. And the importance of case laws are predominantly the fact that they are used subsequently. They're made reference to in terms of establishing a particular court's order to ensure that this guideline or the particular judgment or the order is followed subsequently as well. Nothing more to add on aside from that.
Thank you so much, all of you. I think it is very evident what you just spoke about. I would want to just draw attention of all the participants here about one infamous case, or rather one famous judgment or very important judgment that came about was MJ Akbar versus Priya Ramani. What interested me most is reference of dignity versus reputation, right? So we use dignity and reputation as synonyms. Many a time we say dignity, reputation in the same sentence. But this law made me at least reflect, saying that dignity versus reputation is very, very different. Dignity is something inherent and reputation is something acquired. Dignity is more important. Okay, so the dignity of a woman is more important than a reputation of the man. So that is what was discussed, which stayed with me for a really long time, and it continues to stay. And why some things which was pointed out or which was questioned is why she did not speak up immediately and why she had to wait for so long after the incident happened. So there was a reason given saying that a person may take a little more time than as prescribed in the law, which says 3 months or maximum 6 months. So it is perfectly fine. Second thing that was pointed out here is, why did she take on to a media or a social media rather than complaining to the authorities? So yes, it is a person's choice. Maybe they do not trust the forum which is available, and they would want to choose their own own way of bringing the issue up. And what is the proof? Very clearly, when a harassment happens, it happens within the closed room. It happens when there is no proof. So the burden of proof is not on complainant. If a person is unable to prove that this particular incident has happened with them, doesn't mean it is malicious in nature. Okay, and that cannot be used against the victim. So this was very, very powerful judgment. Any thoughts any of you panel members want to add to what I just said?
To add on, Smita, to what you said, I think this judgment has been a bright, rainbow or a nice light to all the women who wanted to raise issues. During this past few months, I've been doing a lot of trainings on Sexual Harassment at Workplace Act. That is how I like to call it rather than the PoSH Act. So the Sexual Harassment at Workplace Act has been a ray of hope for many women. And when we talk about reputation, dignity, how it does not lead to defamation, and how women have come ahead and complained, and they have stood the test of law and test of time, I think it has been empowering for many women. And we may see a rise in complaints now after the court has shown some trust or some faith in the women complainants. That is one aspect. The other aspect, the judgment is a very recent judgment. It has brought out very important aspects that generally women shy away from complaining. There are various reasons that they quote, and a lot of this has been very reasonably, explained in this judgment. So I think we need to promote very important and relevant aspects of this judgment with regard to proof, with regard to how we move ahead with filing, and this will really pave the way for a much better workspace for women.
Thank you, Aline. So let's move to a few amazing case laws that come up with you. I mean, all these eminent speakers have come up with you. The first to start one is the quite an iconic one, is Rupan Deol Bajaj versus KPS Gill, 12th October 1995. Ashwin, you may want to take that up.
Sure. So this case law is fairly important. I think everybody wants to understand from where the issue stems with respect to sexual harassment at workplace. So this was KPS Gill's uh, one of the junior officers who had complained against him with respect to an incident that took place at a particular official event, at a dinner of sorts. That is what happened. So the question that came into existence was, what would be defining of what would be outraging the modesty of a woman, and the larger question that came into picture was, what is modesty? So I think we'll have to first understand what is modesty rather than looking at what is outraging somebody's modesty, and particularly in this case, women. So modesty does not technically have any legal definition per se until date, because nobody has looked to define it from a gender perspective. It has always been very generic, because modesty can be for anyone. But when you look at the Oxford dictionary's definition particularly, it is basically about the behavior or how a woman carries herself. Pretty much that is what is considered the speech, the conduct, everything is what is considered modesty. In this particular case, the court actually held with respect to the fact that the modesty of a woman is outraged based on the action of the offender in this case, which could be perceived in terms of the kind of act that you do, which would violate their decency from their perspective and not from the perspective of the offender in this case, which is what is important to look at. Even a verbal sexual overtone can be considered outraging a modesty of a woman. So, for instance, going ahead and inadvertently knocking their shoulder, or for that matter, a harmless pat as the person who doing it may consider may still be outraging the modesty of a woman. So the definition is still very fluid, but this set the tone to decide how this entire question of modesty came into force. The other aspect of this was privacy. Privacy is something that I think it's a larger question and a much more contentious topic that we have to take up at a different point of time, I assume. But privacy is what is my space, and at what point of time do I not want somebody intruding into my space? Pretty much similar to trespass in terms of property. You do not want anybody stepping into your property, and um, I think it's safe to say that your body is your property. So you would not want anybody to step in and say, listen, or anybody to come in and infringe any of your personal rights, because you decide what you want to do with your body at the end of the day, which is what this case set the tone for it. But unfortunately, Vishaka guidelines had not come into force by then. So this was one of the most primary cases that put forth the aspect of actual sexual harassment at workplace and defined the entire course of how these guidelines were to be framed. So,
yeah. Thank you, Ashtavad. I still remember a BBC video which was shot by Rupan Deol Bajaj. And the way she speaks after around 17 years of the incident, and she's been recorded then. That, you can see her face cringing then also. So it is very clear a person who's scarred is scarred for life. Okay, a woman who goes through sexual harassment, could be the degree would vary, but she's scarred forever and she can never ever forget it. So that is how impactful a sexual harassment is, and how we should be aware about the modesty, the privacy, which we do not talk very openly. Thank you very much, Ashtavad, for that. The next important one, or in this series that we have picked up, is this famous one which defines workplace. So Jaya Kodate versus Rashtra Sant Tukroji Maharaj, Nagpur University. And Aileen, I would want you to share with us your inputs on this particular case law.
This particular case law is very relevant to the present time when everyone is working from home and we're looking for a definition of what is the workplace. So in this particular case, we see that there were submissions that were made. So specifically to point out, there is para 8 of this judgment which says he also invited her, that is the complainant, to his house. And I will just read it. He has also invited attention of the court to various other provisions, and then it goes on to say, it is contended that by appointing such a person who has no voice against the management, a freedom or power available to the IC was drastically reduced. Then sexual harassment is in relation to a workplace which is a senior college and not a junior college. And then it goes on to say it was not connected with the workplace of the aggrieved woman. He contends that a separate IC should be provided in the junior college, which is a distinct workplace, while senior college should have its own IC, in which no employee of the junior college should have representation. So actually, this judgment talks about two aspects. One is with regard to the workplace. It says that the workplace should be separate for different institutions that are there, and it also talks about how an internal committee should be distinct. The Honorable Bombay High Court in this specific judgment has pointed out that the definition of workplace is very inclusive, and we should not get into the minor discrepancies or the very narrow understanding or definition of the workplace. And the Bombay High Court has further said that the Parliament has deliberately kept it wide, kept the definition of workplace wide, so that it can ensure that any area where a woman may be subjected to sexual harassment is not left unattended or unprovoked for. This judgment is very relevant when we try to construe or try to define our present workspaces, where many of us do not actually work in offices that we are designed to work in, but we have taken up work at other places. So that is how this judgment is relevant to the present time.
But there, Aileen, there are many a time there is a pull and push amongst the IC members and among the external member, because a lot of cases do not get administered by a particular IC because they say it doesn't fall under workplace. So do you as a lawyer feel that IC has or can take a decision saying that if two people are working in the same organization and if they have gone to a particular place, okay, can that be considered as workplace, or can IC say, sorry, it is beyond our scope? Just extending this particular discussion.
Law is very inclusive. So when we talk about the workplace, we go to the definition that has been mentioned in the law. The way the workplace is defined in the law, it is very exhaustive. It cannot be, read in a little or a smaller aspect. So this becomes very relevant, and that is where the role of the internal committee in identifying whether it is a workplace or no works out. Like the case that was earlier mentioned by my colleague, where we talk about Rupandeol Bajaj. Now, where did this incident happen? It happened at a party that was called. Now, that was construed to be a workplace. So, the definition of workplace is very exhaustive to mean where colleagues have met or have been compelled to meet by reason of their work. So, it is the power of the internal committee to interpret it to suit the case at hand and to ensure that justice is done to the victim. Like in the initial periods when the lockdown had started, there were a lot of internal committees who were clueless of whether online would fall within the ambit of workplace. And then there were simultaneously a lot of posts going on WhatsApp that online is also the workplace. So I think we need to move in a more progressive manner and understand that the definition is a wide definition and it can be interpreted depending on the circumstances of every case.
Thank you, Aileen, for that one. I'm to our third case law of the day today. This is Gaurav Jain versus Hindustan Latex Family Planning. Came in Jan 2015. It is regarding IC jurisdiction. So, Rajkumar ji, a little bit of detail about what was the case would really help.
Yeah, thanks, Smita. I think this is very important. I think to understand the background of this particular case. Without that, I think I may not be able to do the justice to make all of them understand what I mean to say about particular judgment. So, if you see the background of this particular case, there was one employee, women employee, working with one of the companies. It's basically, the company's name is here is Hindustan Latex Company. And here the victim or the aggrieved person was working on the contract basis. She was actually working for another company, and that company's name was NACO, National AIDS Control Organization. And she was on deputation here, or probably she was sent on the contract basis by that company here in Hindustan Latex. And she was working to Gaurav Jain. She was reporting to Gaurav Jain. And Gaurav Jain, in fact, had a very dubious record as far as the company was concerned. And this was not the first instance in the company of the sexual harassment. There were many, in fact, but nobody dared to make a complaint against this particular individual, because every employee who was coming working under him were, in fact, the female employees on the contract basis. And they did not want to lose the job. And he was a very powerful guy. And in this particular case, he, in fact, stage managed one trip to Hyderabad to assist one client. And he nominates the victim along with him. And while nominating, in fact, he asked the concerned team to book the ticket. And while blocking the seats, in fact, he blocked the tickets. And his intention was always not very good intentions as far as Hyderabad trip was concerned. So there were 5 people supposed to travel in that particular trip. And in fact, the first day, he, along with the victim, he planned the travel. And also he blocked the seats for them, and they were together in the flight, in the adjoining seats. And when he goes to Hyderabad there, and nobody was there, in fact, they check in the hotel, and while checking in the hotel, in fact, they were given the rooms on the different floors. Within, I think, 10 to 14 minutes, he comes back to the reception and says, "No, I'm not comfortable here. Please shift me to the second floor where the victim is staying. I want to stay in the adjoining room of that victim." And he goes there, and then he, on his request, the hotel adjusts that. And then in the night, he calls her for the dinner and orders the biryani. And then he forces that girl to eat half kg biryani. If she doesn't, then he snatches her room keys also, doesn't give the room keys. And this goes on. In fact, she starts crying and all. Again, then he goes to her room and harassed there as well. And everything was captured in the CCTV and all. And then next day also, in fact, the other two people comes along with him, and he shifted those two people, or the employees, to some other hotel. And three employees, in fact, they were in the same hotel. And next day again, he invites everyone for the dinner in his room. And again, he in fact have drinks along with his colleagues in front of her. And in fact, he was in fact also throwing smoke of the cigarette on her face. And there was a lot of harassment, and they were cracking some jokes and all those things. So when she come back to Delhi from Hyderabad, after 2 months she filed a complaint. But when she come back, she was not in a state of mind, was not in a, I mean, she was disturbed. And after 2 months, she filed a complaint against him of the sexual harassment. And the inquiry then was started by the IC, or the Internal Committee of the Hindustan Latex. Here in this particular case, he challenged the decision. He was terminated. This is the committee's decision or the recommendation here. And he challenged or his contention before the Delhi High Court was that the IC of the respondent had no jurisdiction. So in fact, this company where he was working, it doesn't have a jurisdiction. She should have filed the complaint where she is in fact coming, or the parent organization. But High Court said that nothing doing. She has filed this complaint with the Hindustan Latex where the respondent is working. So this is perfectly fine. These are some key contentions which High Court rules in her favor. The second contention, that IC recommended punishment of removal for petitioner for services, which is again the rules of the employees organizations. Again, the High Court said it is nothing like that. Statutory law is law. So again, High Court dismisses that argument also. And then the third key contention was the complainant was motivated and nullified, that it was made after 2 months. So the High Court made a very important observation. Exactly that was in Priya Ramani's case also. In this case, High Court said that, see, for any woman, and for this particular lady, in fact, who lost her father recently, and she was a sole bread earner or winner in the family, it is not possible for her to come and file the complaint immediately. There could be a lot of repercussions or adverse reactions as far as the filing of complaint is concerned. And in fact, she gathered a lot of courage, or any woman needs a lot of courage, or they need some time to gather the courage and come before the committee and file the complaint. Exactly that is what she did here. And the court said that this cannot be afterthought, and we completely accept this complaint. And the last contention was basically, he said that there was no enough opportunity given. But here in this particular case, I think the court was so, in fact, the court appreciated the decision given by the committee here, and the court said that the committee in fact drafted a 27-page report here, and the court said that this is very elaborate report, drafted very well, and it appears that this is actually drafted, this committee's report in fact looked like a judgment passed by any court. That were the wordings of this particular case. So I think my point here is, I think important here is, see, if you see the High Court, the committee, the way they in fact probably drafted this judgment, I think this is basically a very good learning for all the internal committees, or we as the fraternity. I think there's a lot of learning from this. Here the committee in fact relied upon the oral evidences, relied upon the documentary evidences, and also the circumstantial evidences. So they went into the nitty-gritty to find out and probably appreciated all that evidences. Basically, when they checked in the hotel, they relied upon the boarding cards, who has booked the flight, who actually made the bookings or blocked the seats. Then, in fact, they also appreciated, in fact, where was she when her key was taken, who were there in the room. And not only that, in the committee, in fact, also, in fact, when this guy the respondent was cracking some jokes against her, and everybody was laughing or probably making happy their boss. The court also, in fact, the committee also recommended punishments. Basically, it was counseling against these employees. I think from that sense, I think it's very important. If you see the jurisdiction, in fact, I always say that the IC should make the efforts, should not be restricted. The work should not be restricted to the four walls of the company. They should go beyond that and try to collect the evidences here. So this is very, very important, I think, as far as the IC is concerned. In many of my presentations and in the trainings, in fact, I always tell the IC members, many times people, in fact, when sometimes the lady deletes the WhatsApp messages, and the respondent definitely will delete. the evidences, because lady, in fact, sometimes she feels, suppose my husband sees these messages or someone in the family, I think that would be a problem for me. So there could be the husband probably may misunderstand me, and there is no evidence that time. I always tell that the IC in fact can go beyond that and try to recover those evidences using digital forensics and all. I will not be I won't want to be more technical in this, but I'm also saying that if there are messages and all sent, or probably someone is calling in the late night and all, I think I think I always tell the IC that IC should write to the concerned service providers, mobile service providers, to provide the CDR or the call related records, I can say. But I think IC should, because IC has the powers of the civil court here. I think we should exercise that jurisdiction here, or authority, as far as calling this kind of evidences, which can be appreciated in the during the course of inquiry.
Absolutely, Rajkumarji. I am with you, and there has been a lot of pushbacks many a times where I see legal teams have questioned the IC, saying that why would you go beyond your core work, and why would you do a particular thing? So I think what you said is absolutely a nail on the head.
Thank you, Smita.
So I'm moving to the next one, which is Saurabh Kumar Malik versus the Computer and Audit General of India. Ashtawat, this is something that I would want you to give us a little bit of background. What was the case all about, and what was the observation from the court?
Sure. So basically, Saurabh Kumar Malik brings out the aspect of what is called progressive societies jurisprudence. So, like we discussed in a couple of cases ago, what is defined as workplace? So, which is where this entire problem stems from. How will you determine what is workplace for you to begin the determination of harassment that would have taken place at that workplace? So, what is the concept of progressive society? A progressive society, from when we understand what law is to what today is vastly different. A workplace is not considered the same, like Ms. Aileen had put it rightly. Wherever you are currently with this pandemic, I think everybody is sitting at different locations and working. So can that also be taken into the ambit of what you would call a workplace, which is where this entire case came into play. So this case set the tone to decide what, how will you bring about, what is it called in terms of deciding the concept of where a person would work and what would that person be entitled to in terms of rights in that particular location. So I think this was brought up by Sir Henry Maine, if I'm not wrong, who particularly said that the thesis with respect to progressive societies, I'm quoting him actually, is developed beyond the point at which static societies stop through and the use of fiction, equity, and finally legislation comes into play, which is where progressive societies jurisprudence comes. So what is static society? I think the bigger question or the defense that predominantly is taken by most offenders when it comes to claiming that this was not a workplace. Even for that matter, I think there is a very recent case which came into play, which is Silajit Guha versus Sikkim University. That is also a very, very connected case with this, which talks about whether a private event would be considered a workplace, which is what this also talks about. As in going to a colleague's wedding or a particular person's any function for that matter outside the scope of work, but at the same time with your same group of people in from your workplace, would that be considered sexual harassment at workplace? So this case basically is trying to define workplace, but unfortunately it couldn't, because you cannot put it in a straight jacket and say that this would be the place where you are working and this would not be the place where you're not going to work. So pinning that, I think the beginning of definition of or taking up the case with respect to what would amount to sexual harassment will start off with what would amount to workplace to begin, which is what this case brought about in its entirety. I'm not dwelling into the facts in detail further because that will go more and more on.
Yes, no problem. So what we are trying to say is that jurisdiction is something that gets challenged at every stage. I remember when I was supporting one particular case, which was anonymous in nature, which did not have, which was a little dated. So respondents' first defense is that how are you even asking me this question? how are you even, do you have the right to ask me those questions, right? So these are some things that they generally ask us. And as an IC, we should be assertive and say that we have few rights and this is what needs to be done. And, the principle of natural justice will follow. Yeah. Thank you very much for that, Ashwita. We will move to another very famous case. This is Vidya Khave versus Union of India. Eileen, you would want to take that?
Yes, so in this case, Vidya was the petitioner and she had joined a company. And thereafter, the respondent number two, that is the person here who had sexually assaulted her or harassed her, he was working as a general manager and he was the immediate superior of the petitioner herein. The complaint came to be filed. This happened in the year 2008 when there was no internal committee therein. And this lady went ahead with her complaint. She requested for a committee to be constituted as per the 1997 guidelines. Thereafter, there was another complaint. So, in all, there were 13 complaints that came to be filed by her. So, according to her, the first incident took place in July 2011 thereafter, and the last incident took place in March 2012. Now, this particular lady has made a series of complaints. However, these complaints came to be routed to the disciplinary committee and then the internal committee to inquire into the complaints or the allegations that the person made. Now, the committee conducted an inquiry, evidence was led by the parties, statements of witnesses were recorded, and thereafter a report came to be submitted on 17 February 2014, taking into consideration allegations that were very recent. So the petitioner herein moved the Honorable High Court, and her grievance before the court was one. The inquiry committee did not consider all the incidents that were listed out by her, and they pointed out that there was a lapse on her part or there was a delay on her part in submitting her inquiry or her report to the committee. Her grievances were not dealt with. The other reason she approached the court was that the punishment that was given to the person here was not sufficient and it had to be more uh, difficult or rather more grievous punishment that had to be given. And the third aspect that she said was that there was no finding by the committee that the person was guilty of committing sexual harassment. So the internal committee herein used statements that said it was unbecoming of a person. However, the mandate on them was to understand whether the sexual harassment was committed by the person and whether he was guilty or no. The honorable court here found that this was a fit case where punishment could be enhanced, it could be considered. Now the petitioner here felt that his grade had to be reduced, which was not done as per recommendations, and the punishment should be enhanced to such an effect that it needs to be a deterrent. Now, the role of the employer is something that has been discussed at length by the Honorable Court. And in para 21 of the judgment, while it has discussed the statutory mandate or the legal mandate of what is the role of an employer, it goes on to say that it is very important that the employer should display penal consequences of sexual harassment. They should organize workshops, something that all of us need to learn. That in addition to the mandate of the law, there is also a direction from the court. There should be an inbuilt internal mechanism so that any instance of harassment faced by the woman can be conveyed in a confidential manner. And if the person who's assaulting her is her immediate senior, then there has to be a mechanism in which she can bring this complaint in a confidential manner to the right authority without fearing loss of job or any detrimental action. The internal committee should act in a free and transparent manner in order to ensure that the complaints are inquired into seriously and that too without any bias. The court went on to observe very often men may view sexual conduct in a vacuum without full appreciation of the social setting or the underlying threat of violence that a woman may perceive. So, this is in relation to the earlier judgment. The women perceive a threat and this has to be understood by the internal committee in their inquiry process. And it is therefore necessary to continue to create awareness of the vulnerability of women to all the men employees or the male employees. When a woman files a complaint, it should be promptly looked into. Like in this particular case, 13 incidents were overlooked because they felt it was barred by limitation. However, the court felt that they should be seen together as incidents of sexual harassment, and the inquiry should be made within a reasonable period of time. This court also went on to say that safety mechanisms should be evolved by which women employees can feel free to express their grievances to a suitable higher officer. And finally, it went on to say that inquiry committees should be constituted at the workplace in an expeditious manner, and it is the mandate of an employer which the employer should follow judiciously. So this uh, increases the responsibility on us to understand that as employers, we need to have an internal committee and we need to take cognizance of every complaint made by our women employees.
Thank you, Eileen. Eileen, there is always one issue that gets debated, that who's an employer. Now, while if it is a sole proprietor work or a small company, then you know that somebody who's owning the company, somebody who's founded the company is the employer. But in large corporates where you have managing director who's appointed, the CEO who's appointed, so is that person the employer, or the HR department can play a role of being an employer? So this is one question that gets debated all the time.
If we understand, one of the challenges that this law faces is who is accountable for putting the law in play or in practice. So here the employer would be the one who is holding the highest authority, and the HR manager is someone who looks into compliances specifically to understand that their organization is compliant with the law. That is how I would understand.
Thank you, Ellie. What happens is that if we say that, okay, HR is somebody who's executing it because the outcome comes and disciplinary action is taken by HR, so do we put that person as an employer? So if that person is called out as an employer, can they be part of IC? So I've seen people playing dual roles, that they are part of IC and they are also executing. Okay, so these are some things that we'll take it for another discussion, but I just wanted to table these kind of incidents. So we are moving to the next case, and Rajkumar, we come to you. This is Ashok Kumar Singh versus University of Delhi and others, 18th August 2017, and this was how to write a report. It will be very interesting for us because that is one aspect which gets debated all the time, that what is a conclusive and exhaustive report.
Yeah, thanks, Smita. I will not talk about, how exhaustive report should be while writing, but I think definitely, yeah. One thing I would like to tell to the audience here is in the internal committees, especially the people with the background or the members, in fact, who are working for the cause of women, mainly from the HR, legal, or compliance streams, they are part of the committees. I can understand the people or the members with the legal background, still they can, they have some kind of knowledge about writing the reports or probably making pleas and all those things. But the expectation from the committees who don't have legal background, I think it would be, little more expectation from the committee members, and they're not, in fact, technically or legally sound to write the factual reports or the legal reports. So I think that from that point, I think from that sense, it is very unfair to expect too many things. So in fact, in this particular case, if you see, I will not go to the details of the case. Here, the internal committee drafts a report and make the recommendation against the respondent and submit the report and make the recommendations here. So this matter is basically challenged by the respondent in Delhi High Court, and he challenged this report on 2 counts. So one, he says that there were three. In fact, there were three complaints against this respondent, and he challenged on 2 counts. One, he says that the report only gives the prima facie conclusions of the complaints, having substance without report actually giving a definite conclusion and holding charges against the petitioner to be proved, and which is very much required. If you see section 13(1) and 13(2) of the act, it very much clearly explicitly says that that the complaint should The inquiry should be concluded as well as it should be proved. Those two aspects are very important. And in this particular case, the IC members or the IC try to write a report. And in fact, they mention in the report that the IC holds, they use the word I'm using in inverted commas, the IC holds prima facie. This is one word. And the conclusion which have been arrived at not a final. So the High Court, the contention before the High Court was, it means that it is a prima facie report. The final conclusion is yet to be, the committee is yet to arrive. And secondly, they also said that it has some substance. So there was no reason for the IC to mention these two things, prima facie and some substance. It should be definite, it should be conclusive, and it should be proved. And that was exactly these terminologies or the words have been used in section 13.1 and 13.2 of that.
So it was something that they were negligent about it, or they were not competent. Rajkumar, what do you think was the issue here?
So it appears that they were not sure, because they were not sure that how to write the report. And they said they are saying that there could be some, there may not be evidence proved on all the points on the allegation. There could be few, and where they were saying that, okay, it has some substance. That could be one of the possibility here. So that in that judgment, it has not been mentioned what was that. But I feel that that's the reason it forced the IC members to write this kind of wordings or use this kind of wordings in the report.
Yeah, so one input I think you also train for PoSH, and that is what comes up, is you always write a very compelling report, and always write a report that this could get challenged in the higher court. Write it from that perspective. Okay, write what you have found and as detailed as you could. So that is one input that I always share with the team members. Yeah.
In this case, Smita, if you see, the High Court was very generous here. High Court did not say that your report is wrong. High Court, in fact, asked the internal committee or directed the internal committee to rewrite the report. They did not say you go and do the inquiry, a fresh inquiry. They did not say that. It directed to read up the report and decide the matter. So agreed with this, the respondent went to the double bench judges High Court. It went to the bench and then again made the plea before the court and said that we are not happy with the judgment passed by the concerned court. We have not been given the opportunity. That is what is one of the contention. And he also said that we were denied the opportunity to the cross-examine the witnesses, and we were not permitted to lead the evidence in support of his defense. And inquiry reports were in gross violation of the principle of natural justice, and therefore deserve to be set aside. In this case, I think the court was the double bench judge court, I think, was here again. They said that, okay, this inquiry can be conducted again if suppose an opportunity is not given. Wherever the examination happened, from there, I think the report and inquiry should be carried forward, and the inquiry should begin within 2 weeks. And this is very important what I'm going to tell in this particular judgment. The High Court has said it could be applicable not only to these kind of cases, but all cases. And the High Court also said that IC shall intimate the appellant and the respondents in writing as well as by email of the date and timing of proceedings. And further said that appellant would be allowed to cross-examine the witness of the complainant through a questionnaire, not required to be face-to-face. And again said that witnesses should answer questionnaire in the presence of the IC. Every effort shall be made by the IC to complete the testimony of a single witness on the very day on which the recording of the witness cross-examination commences. It means the court is trying to say that as far as possible, try to complete the same two things on the same day, examination as well as cross-examination. And further, the court says that every effort shall be made by the IC to complete the testimony of a single witness the very day on which the recording of the witness cross-examination commences. And further says, if there are several complaints are there are 3 complaints here. The court is saying that at one go you inquire all the witnesses. Don't again and again call the witnesses for 3 separate inquiries. The court also said that the appellant and the complainant would not be present at the time. See, this is very important. The court is saying that when the cross-examination is happening of a particular witness by the defense or by the respondent, that time the appellant or the complainant and the respondent the other witnesses should not be present in the room. and IC shall make every endeavor to supply copy of cross-examination of the complaint witnesses to the appellant on the date of which the cross-examination are. So it's also saying that it's not only that the witness statements and all in the same time it should be given. The court is also saying that the moment you complete the examination, the statement should be handed over to the respondent. And the moment that cross-examination is conducted by the respondent, the cross-examination should be handed over to the witnesses and the complainant. So I think that is very important. And the High Court also said that within 90 days should come back tell this court that they have concluded the inquiry and decided the matter.
All right, awesome. So we are moving to the next very important case, which was Mera Kotwal versus UOI, Supreme Court, 19th October 2012. It was about implementation of guidelines. So, Ashtavat, would you want to
share? This case actually holds great importance because of the fact that in the subsequent year is when the Prevention of Sexual Harassment at Workplace Act had been implemented to begin with. So until then, it was the Vishaka guidelines that were enforced to govern any sort of harassment that would take place of a sexual nature against women, particularly. So the issue with this case was that even after 15 years of after the Vishaka guidelines had come into force, most of the states and union territories had been very lax in terms of implementing these guidelines or ensuring that these guidelines are implemented, even within the governmental bodies and governmental organizations as well. This led to a bigger question and a larger issue with respect to at what point will or from where does a complainant start to take up an issue with respect to sexual harassment? Because when there is no proper forum or there is no proper mechanism, where do they go and approach it when there is a national or a national level skeletal structure that has been provided? Where do they go within the state to seek such redressal? So the court was very appalled by the fact that predominantly many states have not implemented the guidelines after 15 years. So citing in the aspect of us being the largest democracy in the world, not the oldest democracy. We are the largest democracy in the world with the second largest populace. And we are seeing a great number of crimes against women, which is something that I can safely say that is yet to be to the extent where it has been combated in its entirety. So the court came down very heavily stating that this entire guideline cannot be a lip service, and the major holding of this entire order was it wanted it to be split into three ambits. A victim is there, if they want to raise a complaint, what happens to their career going forward? Because that is very, very, very importantly to be affected because of the fact that if they complain against a superior, they lose their growth within the services, which is finally coming up over the last half a decade, where we are seeing a lot of these questions being brought up, even with respect to the armed forces, which is a prevalent issue that is coming up recently. The second aspect was the court said that was with respect to the Industrial Employment Standing Orders Act, the rules that are basically said that any industry that is established in any state which has not implemented the guidelines even after almost a decade and a half have to strictly implement these guidelines to ensure that there is a redressal mechanism and there is at no point any complaint that goes not addressed. And they wanted these complaints to be even retrospectively taken up and filed with a committee which was supposed to be established even if you come at a taluk level, which is something that is very important because as you go down I may be using the wrong term, the food chain, in terms of how a complaint is brought up to the highest authority, when there is no forum for you to complain at the lowest level or at the lowest district or juncture, how does a person even bring up the case? Which is where the court was very, very cognizant about the fact that irrespective of where you are located, a committee has to be there and it shall be headed by a woman. and as far as possible, the committee shall be independent, because the predominant issue is, even with the committee for addressing sexual harassment cases, is overreach or overpower by external forces, which are from various aspects like government or non-governmental aspects as well. So which became the larger question in this issue. And well, I think at the end of it, it was more on the lines of saying that if at all there was any non-compliance or non-adherence to the Vishaka guidelines that was established in 1997, the High Court would be in a better position to directly take up the cases and give any redressal to any grievance that may come up. And the victim need not necessarily go through the process of trying to find out which would be the right forum to take up the case.
Okay. So, but we are still struggling with it. Many organizations that I know have not implemented the guidelines. We are still after the law also came up, we are still struggling. But that's a different discussion, and we'll have this discussion sometime later. And I'm very mindful of the time. So we're moving to this another very important case law where inquiry when invalid. So, Aileen, you might have to give us a little bit of background of what was this case all about.
So this particular case is very important for us to understand who constitutes the IC. If we see section 4, it talks about an external member being a person who is related or understands women-related issues, a person who is not connected with the organization, and a person who will ensure there is a fair inquiry. That is what the law mandates. Now, in this particular case, we see Ruchika Singh Chabra versus Air France case. It is a case where this person was an employee of Air France India. She was a former employee. She was sexually harassed. And at that point in time, she lodged a complaint with the internal committee. Now, the internal committee had one person who was the secretary of the Employers Association, who was appointed as an external member because he was a lawyer. The appellant, that is Ruchika, she sent several letters to the internal committee asking clarifications of how this particular person qualifies to be an external member of the internal committee. However, none of the correspondence of hers was answered by the internal committee. Thereafter, she went before the High Court asking for clarification or asking for consideration on the aspect that the inquiry conducted by the internal committee in the absence of a neutral external member is invalid. And she also stated that this person who was appointed as an external member, he was in fact a labor lawyer, and he has not disclosed any organization that he works with, and he did not qualify to be a person working on women related issues, and he did not understand sexual harassment at workplace. Now, I have seen a lot of internal committees have external members who are associated with or holding a tangent, responsibility with some way related to the employer. So that is where I felt this case is very important for us to understand the neutrality and the transparency with which an external member should come on board in an internal committee. Now, the High Court of Delhi held that the respondent was in error and that the rule of law was not followed in terms of appointing this external member as a part of the internal committee. The court went on to observe that the objective behind the requirement of a member of a non-governmental organization or association or a person committed to the cause of women or any person familiar with issues relating to sexual harassment in the workplace is to prevent the possibility of any undue pressure or influence from senior levels, as has been laid down by the Supreme Court. In fact, the object of providing a NGO member is to keep IC independent and impartial, and so it should command respect and compliance even from influential management. The court went to say that the Vishaka guidelines are to be taken seriously and they should not be followed in a ritualistic manner. And it finally held that the committee that was formed And the inquiry that was undertaken by this committee was invalid in the eyes of law. So this, I think, is very important for us to understand that if we have undergone the whole process in a ritualistic manner, and if the internal committee is not as per the mandate of the law, and if these minor issues can then lead to, making the whole complaint or the whole inquiry invalid, then we need to first look into the whole process. Just to add on another aspect, the role of the internal committee in identifying the role in identifying the external member, as well as in informing everyone about the mandate of law in having this particular external member, and how this external member qualifies as per the requirements of law, is very important, which did not happen in this case. The complainant did not know any important qualification of how this external member came on board. So the external member here was biased towards the employer. He was a part of the management, and hence this inquiry was held to be invalid.
Yes, thank you, Eileen. That's quite an eye opener that there is something related to this external member being appointed, because there are times when we do a lot of check in the box activity, and I think that was one that needs to be taken care of, right? So the next important one, Rajkumar ji, I come to you about this particular case law, which is about action for non-compliances and intricacies. So would you explain what exactly was the highlight of this particular case law?
Yeah, thank you, Smita. I think before we delve into the judgment part, what are the intricacies of this particular judgment? Let me, I think, first give a little background about this particular case. This women employee working in this organization called as Medanta Hospital, of which was a part of the Global Health Private Limited, and there was an issue with the boss, and he was harassing her, and many a times she brought it to the notice of the CEO of the company, but nobody has taken any action. When she went to the concerned HR head also, the HR head also told, see, I am also employee here, we cannot or I cannot fight on your behalf with the management. So then she made complaints to various authorities, including the Women Commission and all. Finally, the complaint committee, the Women Commission directs the local committee to inquire into the matter. So local committee, when it receives the complaint, so first what they do is the local committee in fact conducted a site visit at the hospital, which is a discrete one, and spoke to the concerned employee, and they found out that there was no committee in existence. And also they found out that there was no display of the penal consequences at the conspicuous places in the hospital. And after that, they issued a notice for them to appear before the concerned LCC to the management and the respondent. And when they come, and when they were asked about why there was no constitution of the committee, no, they said, no, we already have the committee here. And then I think probably they drafted the policy and all those put in place the committee later on, because that time when the LC visited, that time there was no committee in fact in place. And when they issued the notice, and they in fact submitted the false report, and the LC was very much aggrieved. And then LC decided the matter in her favor, this lady's favor, and the hospital challenged the same before the Indore bench of Madhya Pradesh High Court. And they said that there was no reasonable opportunity given to us. We were not heard as a defense, and the local committee was in fact decided the matter on its own, and we were not given any opportunity here. And they also mentioned very important point that they said that in all of the complaints which she sent to the management and outside the to various authorities, she never mentioned about the sexual harassment. She just mentioned about harassment in all the cases, in all the complaints. And now for the first time before the local committee, she's talking about sexual harassment. So this is afterthought. So here the High Court has relied upon few things which I want to just, I was talking about the intricacies. The High Court here relied upon a judgment of Bharat Cooperative Bank Limited versus Employee Union. See, many a times we have to rely upon various judgment. In this particular case, High Court also did exactly the same thing. This is not a sexual harassment case, but all the courts in fact draw inspiration from various courts. So in this particular, if you say, the court is saying that the definition of the sexual harassment can be elaborated. If she has not said before, it doesn't mean there was no sexual harassment. The court relied upon the word. The court said, as far as this judgment of Bharat Bank is concerned, it said that when the word means is used in the definition. I repeat, when the word means is used in the definition, it is hard and fast. Then no other meaning can be assigned. Now, on the other hand, when the word includes is used, the legislature does not restrict the definition or does not intend to restrict the definition. What does it mean here? If you see the definition of the sexual harassment, and it says that sexual harassment includes any one or more of the following unwelcome acts of behavior. The court is trying to say that when the word include is there, then we cannot restrict the definition of the sexual harassment for a particular period of time or for particular interpretation. And the court said that the word sexual harassment must not receive a narrow and pedantic meaning. It has a wide repercussion as well as wide interpretation also here. And hence the court also said that the court decides the matter in the favor of this victim and said she was not provided the reasonable opportunity to put her grievance before the committee. She was not heard, and she was terminated from the job. And the court said and directed the concerned hospital to compensate 25 lakh rupees to the victim here, and also said that they penalize or they impose the penalty of 50,000 rupees on the company or the hospital for non-compliances. And also the court said that she's also entitled for the EPF and other monetary dues. And very important, when such employees in fact are terminated or asked to leave, they were not given the good certificate of when they are working in the company here. The court categorically mentioned here that issue the character and experience certificate. So inexplicably, the court said that there should not be action against her, retaliation basically. But this agreed with this decision again. This hospital went into the appeal before the double judge bench, and the matter is pending there. I think let us see the outcome of this particular case. But I think
to watch. It will be interesting to watch, and I hope it becomes a case study for all of us. But I can imagine the ordeal of the person who's going through it. Okay, it's not easy to go through and it really needs a lot of strength to be standing in front of so many people who are questioning constantly on what you have done. Okay, so amazing. Thank you for bringing that, Rajkumar. Okay, this one again comes to you about Bibha Pandey versus Punjab National Bank, moral policing, not management or IC. After every IC session, okay, I get calls from the management committee saying, what have you done to IC folks? They are roaming around with a stick or a ruler. I try my best to tell them that moral policing is not our job. Yeah.
So I think this case was recently cited on this 16/2020 by the Delhi High Court. This is a Punjab National Bank case where the general manager and there is subordinate working. I think they were in relationship. I think there's something went wrong between the relationship, and this agreed women files a complaint with the committee. And the committee, when they inquire, they come to the conclusion that they were into the relationship, and there is no sexual harassment. So, what is the expectation of the law here? The law says that if there is no evidence here, they should be recommending to the employer. We did not find any evidence here, and no action should be taken. If there is evidence, they should mention that, yeah, we recommend this punishment here. So here, as there was no evidence, they came to the conclusion they were in relationship. Here the IC in fact decided that, okay, fine, let us do one thing. This is not appropriate as far as organization is concerned. They were into relationship. So they imposed, in fact, they recommended the separate inquiry against them for inappropriate behavior at the workplace. And this was challenged by this the agreed women before the Delhi High Court. And Delhi High Court, Brinda Grover, in fact, was the advocate for this lady, for this petitioner. And the court clearly said that the High Court, the internal committee cannot exceed their jurisdiction. They should be giving the judgment on what has been mentioned in the they should be giving only the judgment whatever they are supposed to give as far as the law is concerned. They cannot exceed the jurisdiction. So that is, in fact, and the court, that's the reason it said that the internal committees cannot do the moral policy. They have to remain within the framework of the law. They cannot exceed.
Yeah, these stems from our biases. There are a lot of stereotype thought processes that we have. And yes, very clearly, we can't be moral policing. I think it's a good idea to be reflecting after we make every statement. Yeah. So yes, it's a learn.
I want to add here, because many times we see that, okay, there is always a debate and the questions on the various groups. In fact, people ask whether video conferencing can be done or whether we can inquire through the video conferencing. In this particular case, the High Court, in fact, has used the video conferencing, and they're categorically mentioning the judgment through video conferencing or via video conferencing. So I think taking the cue from this judgment, I think whenever we get this opportunity, we know that there needs to be signature and all. We can discuss that aspect later on and how that signatures needs to be covered on the same day when we are conducting those inquiries, when we are doing the inquiries via video conferencing. I think, but we can do this. That is what I was trying to say.
Absolutely. Thank you very much for that, because that comes as a question all the time, Rajkumar. So this again comes to you about Maharashtra Bandhu Ragde versus State of Maharashtra. So would you want to share highlight on this?
Yeah, this is very unfortunate judgment given by the Mumbai High Court, one of the judges of the Mumbai High Court. Here, this is basically a case of molestation under the PoSH Act, which was initially the FIR was filed here, as well as the IPC here. In this particular case, there is a 12-year-old girl. She tells her mother that I want to buy some guavas, and she goes out of the house. And this respondent here, under the pretext of giving a guava, takes her to a room and lock her, and then he tried to molest her. And he molested her, in fact. Thereafter, she was scared, and she, in fact, was about to scream and all. Then she screamed because he tried to remove her clothes and all. But before that, he molested her. And this lady, in fact, mother of this girl, was worried, and she actually started looking for her daughter. The neighbor said that I heard your daughter's while screaming in the background somewhere nearby, and she points towards one particular room. And the respondent actually was coming out of the same room. He was getting down from the stairs. She asked that particular person, "Have you seen my daughter?" He says no. And when she goes up, the room was locked. It was in fact bolted. And she opens that, and she went inside and found her daughter there. So you can understand. So in this particular case, the matter was decided by the trial court, and this goes for the appeal before the Bombay High Court, and the Bombay High Court decided the matter. And very unfortunately, the way the High Court decided or interpreted this matter is very disturbing. Here, the contention was whether the pressing of breast and attempt to remove salwar would fall within the definition of sexual assault as defined under the PoSH. So the High Court again rely upon the definition also. It says that whoever with sexual intent touches the vagina, penis, anus or breast of a child, or makes the child touch the vagina, penis, anus or breast of such person, or any other person, or does any other act with sexual intent. The act of pressing of breast of child of 12 years in the absence of any specific detail as to whether the top was removed, whether he inserted his hand inside the top and pressed a breast, would not fall in the definition of sexual assault. So that was the interpretation given by this particular High Court, particular judge. So how it can be, exactly if you interpret that way, then probably, for example, if I'm wearing the hand gloves and touching someone, or probably hitting someone or throttling someone, and someone dies, so it cannot be because I'm using the gloves, I did not touch. So that cannot be interpretation here. So that was immediately challenged before the Supreme Court, and Supreme Court gave the justice and said that we state the decision as far as this court has given. Although the guy was convicted under section 354, which is outraging modesty of the women, where the court said that there are the use of criminal force with intent to outrage of the modesty of the women. That was in fact done. And also there were some other sections, sections which doesn't have many too long. I think the harsh punishment, such cases, in fact, he was convicted, and totally it comes to only 1 or 2 years. That's it. If he would have been convicted under the PoXO Act, Protection of Children from the Sexual Offences Act, it could be probably around 5 years of conviction in this particular case, or probably more. So which
Yeah,
was
that was quite a sad actually act, the whole case study, and it actually gathered a lot of attention, lot of views. Yes, it's really sad that happened.
So I think of course, it was not a purely sexual harassment at the workplace, but I'm trying to say that we have to give the wide interpretation. That is how that law is very progressive. And if you see, because earlier those cases which were not covered in the past, now they have been covered under this act. All the instances still which were not covered, we have to bring all those incidences as far as the sexual harassment is concerned. We cannot say it is not falling under these 4 or 5 sections, subsections which were mentioned in the law.
So that's what we say, not only by word but also by spirit, right? I think that is also very strongly spoken about. So the last case of the day is we go to Ashtavad. Ashtavad, can you share with us what is this case study and what is the learning from this case law?
Sure. So the last case is basically Bhuvan Chandra Pandey versus Union of India again. So this is a very recent case, which again talks about, again, I had spoken about this particular aspect in the last case law that I had brought up as well. What is the effect of a woman's, as in from a career trajectory, what happens when they issue or raise a complaint against their superior officer or any other person who was superior to them in terms of the organizational hierarchy. So this case is basically about women cadets who are in the training at based on their SSP selection. And I think the facts of the case go in a very brief way to just state that it was, I think they have a training module, and based on the training module, they're supposed to go through a march past. And that particular night at the cantonment, apparently it was there were heavy rains and it was a lot of slush. So the option was to not participate because there can be a physical risk in terms of you having incurring any injury in the process. So the women cadets were given the option, but what unfortunately happened is these two cadets chose to go for the, unfortunate because of the forthcoming incidents after that, they chose to go for the march past, and after which they were asked to get into a particular van, and where they were traveling with I think a couple of other senior officers, and where this particular woman was molested again. So the concern that happened in this case was what happens if she raises a concern stating that I was inappropriately handled by one of my superiors. It works out in a larger question of when you're in the government service, because your salary is affected, your pensions are affected, your overall retirement benefits take a hit, because the number of years of service in a particular level is hit. You're docked at a particular level, and if you do not move to the next level at that particular number of years of service, your benefits that you derive out of being in the government service is going to drop. So essentially, irrespective of public or private enterprise for the matter. So the government basically stated there was an internal committee that was constituted for this particular case, but unfortunately the committee was again amongst the same set of officers predominantly who were taking up the issue, and there was not much that was done with respect to this issue that the woman did raise, but after a certain point of time. The important point to note is that eventually they did constitute a 3-member committee which had 50% women, and they did impose a penalty. The question of penalty is what comes into play in this entire case law. It says that the power to reduce penalty imposed by a disciplinary authority does not vest with a court or a tribunal ordinarily. The court, only when it undertakes a judicial review, and here's the case again, when it comes to an appeal, can even consider reducing the penalty. If not, it would not substitute its own opinion in any other matter. So this case brought out the entire issue as to who had the authority to determine what the penalty was. So even to the extent where the courts are saying we do not have the authority to determine that this penalty can be reduced irrespective of what the nature of the issue may be. If the penalty is set by the act, and that is the penalty that has to be imposed, pretty much.
Thank you so much for that. That's pretty important because being able to implement the whole aspect is important, and unfortunately, it is still not there. We are struggling. We are understanding those gaps, and that's why these case laws are so important. It comes really strongly for us. So I'm going to pause here and open up for a few questions. I know we have short over time, so back to everybody. And we open up for any questions. You have the entire team here. If there are any questions by the team, we could take on. If you are putting up on the chat, please go ahead and do that.
Hi, this is Aparna here. Thank you so much, Smita, and thank you, the panelists. I think it's just been fantastic to hear, the entire case laws that you spoke about. What I would be interested is to know, has there been any case laws against women? While I understand, we all understand the PoSH, right, the entire act, but there has been instances where women have taken undue advantage. I'm coming from there, having dealt with a few cases, so it would be interesting to know on those lines. So that's what I wanted to know.
Yeah. Anybody wants to take that?
Yes, Smita, I'll answer Apana's question. Apana, I really do not recollect those judgments. What are the judgments? But I remember two judgments. One was the judgment from decided in the Western Railway. In that particular case, subordinate alleged against the boss for the sexual harassment, and he retires. And after 10 years, the High Court decided matter and said that this is a false complaint and a malicious complaint filed by the complainant. And after 10 years of the retirement of that particular respondent or the employee, senior employee, the court imposes fine of 10,000 rupees against the employee who is in service. So that was one judgment. And second judgment, recently, I think 2 weeks ago, I think there was one judgment passed by Delhi High Court. I think that Delhi High Court gave the strong message to the concern that for filing the malicious complaint. So I don't recollect the name, but if you want, I can find out that and share with Smita. Smita,
sure.
With you. But
absolutely. No, I think it's so important because we are being, while we talk about inclusion and we talk about, gender equality and all of it, but, like I would always look at the dowry, harassment, right? Yes, those are some laws that are there to help the women, but unfortunately, a lot of other things also happen. So yeah, I think men don't come up for various reasons. I haven't had too many men complaining. Even if they do, they don't want to give a complaint in writing, right? For various reasons. So yeah, maybe we can discuss offline. I do not want to take up more time on this.
Thank you.
Thank you so much. Thank you, Smita. Thank you, the panelists. Thank you, Rajkumar.
Just one more question. What happened when the employer is a court or a judge? Vishaka guidelines, can any panelist cite any example? Employer is a court or a judge?
Smita, I did not understand this question. Other panelists, if they want to answer this.
I think this is, he's saying if the respondent is an employer. I think that is what, I think that's the question. Bhargav, if you would want to rephrase that question, that will be helpful because it's a little confusing what you've asked. Another one, the more powerful the institution, the more challenging it becomes to ensure fairness. I think fairness in the process. What can India learn from other jurisdictions for addressing allegations of sexual harassment against judges in higher judiciary? I think they are speaking about the CJI fiasco that happened, where the judge appointed the internal committee to investigate about his own case, regarding his own case. I think they're mentioning about there. Are there any best practices we could adopt? Chandra Mishra, I have been doing a little bit of research of global laws, all right? And I have reviewed US laws and I'm looking at various other country laws, okay? I realized that India has a very stringent law. And there are times when multinational companies are appalled by the kind of detail that is available in the law. We do not have any country, I can't say any country, but many of the countries I can say definitely do not have such stringent laws. I think they should take a learning from us for a change. Yeah, yes, but about the judge, there are some things, there are some loopholes which we need to work very strongly about. Anybody wants to
Smita, my suggestion here is I think the women need to fight out. Otherwise, see, in this particular case, we're talking about the CGI. So I am not saying whether this allegation was right or wrong, because the lady was so, in fact, upright, and she stood, in fact, what she was saying and what she alleged. And she was all alone fighting because there was no representation given to her. And she was speaking to the three topmost judges of the country. Try to understand that. And she, after that, whatever the it was not decided in her favor, but at least after that she could retain, she could get the job back, not only her job but also I think her husband as well as her brother-in-law. If she had filed a malicious complaint, why action was not taken against? So there are many questions remain unanswered, but I think whatever it is, she got the job. That at least that we can say some sort of justice done to her. Otherwise, she would have been without any job. Not only she, but her husband as well as her brother-in-law.
Okay. All right, that's awesome, Rajkumarji. It's 8:32 and 1.5 hours, and I still see questions flowing, but we will have to take a logical closure. Thank you very much. I'll try and copy these questions and bring it to the panelists' notice, and if they can respond to us, we could email it back to you. All right. Please write to us at info@kelphr.com with your questions, more questions, and I will ensure that we respond back to you. Thank you very much. Any closing comments from any one of you would be really helpful.
I think it's a very insightful, session, because many people do. There are flip sides to every single aspect that is being discussed over here. But again, this is a topic that has been contentious for over 3 decades now, and still going on. Like you rightly said, I don't think anywhere across the globe is there a solution to this problem, because I think it's unfortunate that people look at it only from a very national perspective, but when you look at it on a very international level, every country does have a great extent of cases of this nature. Just that we do not hear or see or read about it unless we take that effort to see it. And the quantum of cases that we claim to be on a very high level in our country is pretty much the same across the globe. It is not different anywhere else. And yeah, I think it was a very insightful session. I would like to thank the panelists as well, the other panelists who came along with me, because a lot to learn from them, way too senior to me. So it was good to know that. And I'm also going to thank my colleague Tanuja, who was helpful in this process to me.
Thank you. Thank you so much.
Thank you, everyone.
Thank you, sir.
I would just like to say that this was a very informative session, in as far as we gathered together quite a few case laws. So actually, all of us, including the panelists and the participants, have undergone a process of capacity building, where we've understood how the law has evolved. So this 1.5 hour has been learning for each one of us. And I think this is how we need to proceed even with our inquiries. We need to upgrade ourselves with whatever judicial trends are there from time to time, so that we are more effective in our work as internal committee. And if you look at all the participants here, they are members of internal committees from organizations. There will be a few lawyers. So this aspect of bringing about judicial trends right from 1997, from when the Vishaka guidelines came in, and there were some case laws even before that. So we are trying to understand that it is a issue that has been, hitting all of us at some level, and the whole procedure and even the law is evolving, and we need to compile a lot of these judgments, and maybe we could work out some way of disseminating this information, so that a lot of others could, or everyone could benefit from the plethora of cases that we have. So
Absolutely.
thank you for this opportunity.
Absolutely, Aline. At least these 12 cases that I have collected, I'll try and put it in a flow and combine what learnings I had and try and publish it. So that is my promise, and I'll keep collecting such cases and try publishing it. If you all have anything to add to that, we'll be more than happy. Yes. So thank you very much. So we close our session. Rajkumarji, thank you very much. Ellie, thank you. Ashtavad, I hope I'm pronouncing it correctly. Thank you so much.
Thank you.
Thank you.
Thank you.
Good day to everyone.
Good day.